Hi everyone, it's 9 a.m., so we're ready to start with the panel. Welcome to ILW.
Great, thank you, Jane. Hello, everyone. Good morning and good afternoon and evening, depending on where you are. My name is Elizabeth Nielsen. I'll be moderating. Thank you all for joining, and many thanks to our distinguished panelists who are joining us now from all around the world. I'll start with just quick introductions because I know they're eager to jump into the questions. For the members of the audience, if you have any questions as you go, if you can send them, there should be a Q&A box or through the chat function. We'll plan to kind of hold those for the end and respond to them to the extent that we've got time. So our three panelists today are, we've got Kevin John Heller, who's the Professor of International Law and Security at the University of Copenhagen, Professor of Law at the Australian National University College of Law, and an academic member at Doughty Street Chambers. Fiona McKay, who's currently the Senior Managing Legal Officer on International Justice at the Open Society of Justice Initiative, and also the former head of the ICC Victims Participation and Reparations Section. And Alex Whiting, currently the Deputy Prosecutor of the Kosovo Specialist Prosecutor's Office in The Hague, and also the former Investigations Coordinator and Prosecutions Coordinator at the ICC Office of the Prosecutor. So let's go ahead and begin here. Since its inception, the ICC has faced criticism from members and non-members alike. Most recently, the United States imposed sanctions against the court and Chief Prosecutor Bensouda and the head of Jurisdiction Complementarity and Cooperation Division. Kevin, let's start by setting the stage. Can you set out some of the external attacks on the court and describe the overarching criticisms that are commonly lodged against it?
Sure. First, let me thank the International Law Association and you for the invite to participate. There are obviously an awful lot of external criticisms that we could discuss, but let me just focus kind of briefly on, I think, two of the most common and most important. And the first is that the ICC is biased against certain regions, against certain states, against certain individuals, even against certain religions. Now, of course, that's par for the course for any international organization, and the charges rarely have any merit, if ever. But some states, unfortunately, have the power to punish the court for its alleged biases, and the US, of course, is foremost among them. And here I'm referring to the sanctions that you mentioned imposed by the Trump administration in response to the Afghanistan investigation and to a lesser extent, the preliminary examination into the situation in Palestine. The sanctions are incredibly vicious. They deny visas and freeze assets, not only for non-Americans who work at the court, but also non-Americans who, quote, materially assist it. The sanctions, as people have pointed out, could even apply to victims who testify against perpetrators. And I think we have to mention that the sanctions also have already had a fairly significant effect. As you've mentioned, Fatou Bensouda and the head of the Jurisdiction Complementarity and Cooperation Division have been denied visas to enter the US, and the ban applies to the families of banned people as well, which is kind of the most appalling type of collective punishment. Fatou Bensouda's US bank accounts have been frozen and her credit cards have been canceled. At least one special advisor to the prosecutor for children in armed conflict, ironically enough, has stopped working with the court because she has dual citizenship in the US and Ireland and might be subject to the sanctions. And sanctions are even having an effect on how states are seeing the upcoming prosecutor election. It seems that some European states don't like the shortlisted candidates because they don't think they have the stature to stand up for to Washington. So it's not just a criticism, it's the power behind the criticism. Then the second one I just briefly want to mention is the very common criticism that the ICC is a weak institution that is utterly dependent on the willingness of states and the Security Council to support it. That, I think, unfortunately, is a more legitimate criticism, particularly concerning the Security Council, whose failure to support the court is, I think, fairly legendary. And here there's a laundry list of issues. You know, the council refers situations in Darfur and Libya to the court, but refuses to pay for them, simply exacerbating the court's ongoing budget problems. The council has done nothing, I mean, literally nothing, to help the ICC enforce its arrest warrants, to obtain evidence, and so on. The council won't even act when the court refers a state's non-cooperation to it, as the court has done once regarding Libya and on 6 separate occasions with regard to state parties that failed to arrest Omar al-Bashir. It took a coup in Sudan for Bashir to finally end up in custody. In fact, I think the council has been so useless that the judges no longer even bother to refer non-cooperation to it because they know it's pointless. And that was the case most kind of dramatically with Jordan. So lots of criticisms, some more valid than other, but it's not, again, about just the criticisms themselves. It's about the underlying power dynamics that give bite to those criticisms. That's what we really have to worry about.
Thanks, Kevin. And of course, the criticisms of the court haven't been limited to outsiders. In April 2019, the first 4 presidents of the Assembly of State Parties published an op-ed entitled "The International Criminal Court Needs Fixing," calling for an independent assessment of the court's functioning by a small group of international experts. Alex, turning to you, many say that this review was a long time coming. What do you think ultimately prompted the call to action and the eventual resolution establishing the review?
Thanks, Elizabeth, and thanks to the other panelists and to everybody who's participating. This is a great topic to be digging into. So I think that really what prompted that article and the review is simply the failure of the court to deliver results. And we'll talk about why that is. Kevin's touched on some of the reasons, and I want to pick up on that in a moment. But I think that after nearly 20 years, and we're almost through 2 prosecutors, the court has very little to show for itself in terms of results. It has only a handful of prosecutions, 3 convictions, 3 convictions for core crimes, a few other convictions for obstruction of justice. And that's it. And I think that in comparison to the ad hoc tribunals which preceded the International Criminal Court, which tended to have better results, people expected more from the International Criminal Court and are disappointed. But I think there are 2 things that are worth noting about the article that you mentioned from the 4 former presidents that spurred the expert report and the expert report itself. First of all, it was, as I said, about results. And that there's no escaping that. There's no escaping that metric of success for the International Criminal Court. There's a lot of discussion about what the court is, what it should be, what success is for the court. And there's discussion about whether when it takes a stand, when it opens an investigation, when speeches are made, when symbolic acts are made, whether those are successes for the court. And they may be steps forward, but ultimately what should be clear, and I think is clear from this judgment and the expert report, is that success is going to be measured by results, and results are cases. This is a judicial institution. It's where criminal cases against individuals are prosecuted, and it will only succeed if there are cases against individuals that are prosecuted to conclusion. The second thing is that if you go back and look at the op-ed that you mentioned by the 4 former presidents, they actually talk about 2 reasons for the troubles of the ICC. One set of reasons is the reasons that Kevin mentioned: the external forces, the failure of states to provide enough support for the court. And the other is the internal dynamics, the internal problems within the court, the failures within the court. But the expert report is focused entirely on the internal problems. And that's another lesson to take away here, is that no matter how much the external forces limit the successes of the court, and they do, ultimately, if the court fails, it's going to be the court's fault. The court will be blamed, the court will suffer. And the court has to find a way to succeed in the environment it exists in. We can keep saying states should support it more, they should give more money, they should back it more, and that's the problem. But that's not likely to change. If we want success, the court has to find a way to succeed given those constraints.
Thank you, Alex. There's a lot that we're going to want to unpack there. But Fiona, turning to this independent expert review, can you tell us more about the procedure for that? So kind of the composition of the group of experts, the involvement of the court staff, state parties, civil society. What are your initial impressions of this process?
Sure. So, and also as other panelists, I'd like to say how pleased I am to be taking part in this really fascinating panel. So this panel was appointed by the states parties last December and began work immediately in January. Briefly, the panel is made up of 9 experts who have the kind of background you'd expect that are relevant to the task. They're judges and prosecutors from other international courts and organizations. The panel's been chaired by Richard Goldstone, who many will be aware was the first prosecutor of the tribunals of former Yugoslavia and Rwanda, and an eminent South African judge and eminent figure in the field of international justice, of course. The experts divided themselves up into 3 groups of 3. 3 of them focused on governance questions, 3 of them focused on the judiciary, and 3 of them focused on the prosecutor's role, broadly speaking. The states parties had requested the court to grant unhindered access to both staff and documents, and the experts say they got that. Most of the work was done under COVID restrictions. They started their work at the beginning of the year, but then of course quickly hit the COVID restrictions. They finally issued their report just recently in September. So there had initially been a lot of calls from different stakeholders, especially civil society and the situation countries, for the members to engage with them, even to visit maybe some of the situation countries to hear from the places where the court had intervened about how people had experienced that. Of course, that wasn't turned out not to be realistic anyway because of the pandemic. They did hold a virtual meeting with civil society. And they managed to somehow do a total of 278 interviews and meetings, many of them virtual, with officials, with states parties, with council, the court's staff union, NGOs and academics. And they also received a lot of written submissions. And it seems to me that it's quite clear that despite the time limits, despite the difficulties presented by the COVID restrictions, looking at the report and the way the findings are set out, they really do seem to have heard and listened to pretty much what I'm aware of as being sort of the full range of concerns that are raised. So I think they did an exceptional job despite all those limitations.
Thanks, Fiona. And the final report, as you mentioned, so it covers a lot of ground. The final is 350 pages, so we're not obviously going to cover everything here. But turning to just kind of the high-level reactions, Kevin, you once predicted that the review would turn out a technocratic critique that doesn't begin to grapple with the court's larger, more structural issues. What are your general impressions of the first report? Do you think it addressed those structural issues?
Well, I definitely have to confess to being at least slightly wrong. The experts did offer some minor technocratic recommendations, quite a few of them actually, but they definitely didn't shy away from some of the big picture, more structural criticisms, and I think they deserve quite a bit of credit for that. That said, I think I was kind of right to be a little pessimistic about the report. I think it's very uneven. I think it's strongest on governance issues, where I think it makes some really important contributions. And I think their most important is the demand for a zero tolerance policy concerning bullying and sexual harassment. Such harassment, particularly of vulnerable female interns, as the report notes, has always been rampant in the court, in the OTP, in the judiciary, in the registry. And here, I think the report's recommendations are incredibly useful and, really most welcome. A more robust internal complaint system, real professional consequences for individuals who abuse their power, regardless of whether they're judges or the prosecutor himself. And very importantly, more women in senior management. Again, I think the governance issues are really strong. I think the report is much weaker when it comes to prosecutorial and judicial practice. And I'm looking forward to hearing what Alex has to say, because he has such a vast background as a prosecutor. I think some of the expert recommendations, they sound really good, but they will do very little. And let me just give you kind of my two favorite examples. The report says that the OTP would benefit from, quote, focusing on the factual allegations that are supported by the strongest and the most diverse evidentiary basis, and should refrain from relying on weaker allegations. To which I'm pretty sure the OTP would no doubt reply, well, duh, of course, that's what we always want to do. And then kind of similarly, the report calls for the judges to demonstrate, quote, consideration and appreciation of alternative or different points of view or perspectives. To wish them, I wish them all the best with that recommendation. So beyond that, I think there's even some recommendations that are counterproductive, and I would take issue with. I think one critical example is the expert suggestion that the appeals chamber develop some kind of special procedure whenever it wants to deviate from its previous jurisprudence. And they really mean a special procedure, notifying the parties about the potential deviation, inviting written submissions, maybe even hearing argument when necessary. And I think this is quite simply a terrible idea. Most obviously, deviation is very much in the eye of the beholder. Whether to trigger the special procedure will become just another thing that the judges will fight about. And we can see that by looking at the only example that the experts actually cite in defense of a special procedure, which is the acquittal in Bemba, where the commentators, a lot of commentators, not me, complain that the appeals chamber didn't defer enough to the trial chamber's factual findings. If you look at the judgment, the judges in the majority did not believe that they were changing the standard of review. So presumably they would not have agreed to this special procedure had it existed, and if the minority had asked for it. It's also worth noting that the procedure would considerably delay appeal judgments, which is something that the experts complain about elsewhere. And then just finally, I think there are also some problematic absences in the report. I think most notably, although the experts spend considerable time discussing prosecutorial and judicial practices that lead to supposedly unjust acquittals, they basically ignore problematic practices that have led to unjust convictions. And here my pet example, as always, is the Katanga case, where the trial chamber convicted a defendant on the basis of a mode of participation in the crime that the prosecution didn't charge, and that the prosecution didn't even mention at trial. The trial chamber simply changed the legal characterization of the mode of participation 6 months after the trial ended during its deliberations. That power to recharacterize is not in the Rome Statute. It appears only in a regulation of court. And guess who wrote the regulation? Well, the judges themselves. That practice, which is extremely aggressively used at the court, both by the OTP and the judges, is simply not mentioned anywhere in the report. They seem much more convinced with the wrongful acquittals than the wrongful convictions. So it's a mixed bag, and I'm going to be curious to see what the court implements and what the court doesn't from this list of 384 recommendations.
Thanks, Kevin. And that tees us up really nicely, Alex, for the next question to you. Given your experience working in the Office of the Prosecutor, what are your thoughts on the final report's recommendations for the OTP? Do they address any of the concerns that you were referencing earlier about the internal functions of the court?
So I agree in part with Kevin, and in part I disagree. I think that there are a lot of recommendations, and so there can be debates about some of the recommendations. Kevin has mentioned a couple of them. I have slightly different views about the ones he's mentioned, and there are debates surrounding some of those particular recommendations or findings. And it's also because there's so many different recommendations. it's possible to look at the report and pick and choose and say, well, this vindicates what I've been saying all along, or so forth. So depending on how you focus on the recommendations or on the report, you can see lots of different things in it, and support for different positions, or not support for other positions. But I think that what I would say is, if you step back a little bit from all of the recommendations, I think there is a larger picture for the OTP that I think is important. And I think the message is that there has to be a change in culture. And I think that change, what the report recommends, is a change in 4 ways to the culture. The first is there has to be more strategic thinking. And here the report recommends that the prosecutor focus his or her energies, narrow the number of cases, and focus in on cases that are likely to succeed and that are particularly grave. So trying to have a more strategic approach to the work overall, and trying to have it focused and success oriented. The second part of the change in culture Kevin mentioned, and I think he's right about it, is about changing the atmosphere in the court, to eliminate any tolerance for bullying or harassment, sexual harassment, or harassment of any kind. The third is to create a culture of accountability. And here I think it's accountability for behaviors of the kind that we were just talking about, me, Kevin, and myself, but also accountability for results, and holding people responsible for achieving results. And if they don't, then they're held accountable, and either they move on to a different job, or they improve their practices. And that's both for individuals and also for the work of the court as a whole, for its practices, its policies, its systems of doing work. And then the final cultural change that I think is required, and is you can feel in the recommendations of the report, is there has to be a new level of urgency at the court. There has to be a feeling that that deadlines matter, that expedience matters, that efficiency matters, that the cases are advanced quickly and brought to court and brought to justice in an expeditious way. There's lacking a kind of decision. Let's make decisions. Let's stick to the decisions. Let's have a plan, and let's move forward. That's throughout the report. And Kevin's right. Sometimes the report uses sort of vague language or careful language, but I think if you read them as a whole, those are the 4 points that come through. And if the new prosecutor focuses on those 4 points, I think it could be very important reform.
Thanks, Alex. Fiona, before we turn to kind of the next topic, that was a lot of ground that we've covered with these recommendations, and particularly these changes of culture and the 4 aspects that Alex just described. Do you have any reactions to that or to the points that Kevin raised earlier?
Thank you. I did want to take issue with one thing that Kevin said about the essentially, as I understood him to say, it wasn't a problem that the judges take differing. The judges should be entitled to have different opinions and things. I certainly don't take issue with that, but I was very concerned about what's said in the report about the lack of culture of deliberation between judges, the lack of collegiality, the apparent dysfunction in some chambers, and inability to even try to for example, share their views and reach some consensus. And I do completely agree that you shouldn't try and force judges to, in any sense, to have the same views, and that of course that judges should be entitled to issue dissenting opinions. But I do think it's a real problem that these kinds of that if consensus is being prevented just by these kinds of mechanical ways, and the lack of this culture of deliberation and this sort of dysfunction in how chambers operate. And I would go further than that and say that, to take the Bemba case, the Bemba decision of the appeals chamber that Kevin mentioned, I do think that the fact that the appeals chamber departs quite significantly from the previous ICC approach to what is the appellate standard of review is significant. So if you take away the substance and merits of what they were talking about, what they were considering, and look at that, I think that I can see in some instances that there should be some care taken to try to have some consistency and coherence in terms of those big kinds of questions.
Thanks, Fiona. Kevin, anything that you want to respond to on those points?
I mean, just very briefly, I don't think on the judges, Fiona and I are actually disagreeing at all. I think my point is really that the report does a decent job of kind of identifying the problems. And we all know that the chambers have been extraordinarily fractious and very difficult personalities, and have created all kinds of problems for themselves. I guess I'm just skeptical of a report of this nature being able to really offer anything that will fix that. I mean, to me, there's no kind of magic recipe to make judges get along with each other better. And I think it's kind of ironic that, that the judges who came up with the recommendations in the report have worked for institutions which were probably even worse than the ICC in terms of collegiality. I think the only way you solve that is through electing really, really good people. Once difficult people are there, I don't think there is a way to overcome those differences, and just kind of suggesting that you listen more carefully to your colleagues. I mean, to me, it's just kind of, empty rhetoric. But again, I think they've done a really good job identifying some of the key problems, such as 184-page separate opinions when the majority opinion is only 30, not issuing written judgments at the time where they actually decide the case. Those are real problems, and those kinds of recommendations, I think, can be incredibly useful.
Thanks, Kevin. Fiona, turning back to you, as the Senior Managing Legal Officer and the International Justice of the Open Society Justice Initiative, we'd love to hear your thoughts on the report's recommendations pertaining to civil society relations, as well as the underlying civil society perspective that permeates the entire report. Do you think that the review process adequately took into account the suggestions of civil society organizations?
Well, both when I was at the court and afterwards, since I left the court, working with civil society directly, I've been hearing the same concerns essentially from the side of civil society consistently over many years. And I should say, when I say civil society, I'm talking about lawyers, local NGOs, community leaders, organizations, the media. So it's not just human rights organizations or whatever, it's much wider than that. So the three most common concerns that I've heard over the years: one, court staff don't understand us, they don't understand our context. Two, court staff treat us like we're there for their convenience. They don't take us seriously, don't try to build genuine partnerships. And in my experience, I would say that civil society actors, for the most part, do understand the need for independence, not just from the court side, but them, the importance of them maintaining their independence as well. And thirdly, the court doesn't make enough effort to explain its actions. And, you know, we, civil society, have to do that for them, and that puts us in a really difficult situation. So the experts clearly heard all those concerns, and they understood that it's about broadly two things. First of all, of course, the court, and especially the prosecutor's office, needs to get the support it needs in order to conduct effective preliminary examinations and investigations. It needs to be able to gather evidence effectively. So there are recommendations there about the OTP investigators spending more time in the field, for example, and making known what good evidence collection principles look like. But I think beyond that, the experts also understood that building and maintaining relationships with civil society is important for wider purposes, you know, for bolstering support for the court, countering negative propaganda in a country and misrepresentation about what the court is doing, which quite often happens. And they suggested, they recommended things like, you know, again, nurturing the relationships of civil society, and improving communications and outreach strategies, conducting workshops, you know, very specific things like establishing a scholarship fund for journalists from situation countries. So I was pleased to see the experts responding to those concerns and making some quite concrete recommendations.
Thanks, Fiona. And from here on out, I'm mostly going to be opening up questions to the group. But starting with Kevin, you'd identified several points that you think should have been addressed in the report and weren't, so the absences. Alex and Fiona, are there any other points that you think the report should have addressed and didn't?
No, not really. I mean, to be honest, I didn't focus on that. I tried to see, because there was so much in the report, my concern was that it had tried to cover too much ground and that its focus was therefore dissipated. And so when I read the report, I wasn't really looking for what was missing, but I was trying to think of how it all came together in some sort of coherent whole. I'm sure that there are, I have no doubt that there are certain issues that should have been addressed, you know, more directly or better, and then things that are left out. I'm not saying there aren't. I didn't focus on that.
Maybe just to add one thing, I agree. There's so much there. It's hard to say that they left things out. One inconsistency in the report I thought was interesting is that the experts go to a lot of effort to continually stress the problems caused by lack of coherence, lack of standardization in, for example, judicial processes, especially judicial practices, you know, when they're considering how the proceedings could be more efficient. And they call for lots of things to be standardized and reflected in practice guidelines and in the regulations of the court, disclosure of evidence, that kind of thing, how to manage confirmation of charges hearings. But then they inexplicably recommend that two rather fundamental issues not be regulated. One of them being questions of admissibility of evidence, you know, whether there needs to be a determination that specific pieces of evidence are admissible or not. And one of the reasons that sort of made me chuckle, if you like, is that I don't know, it's only speculation as to whether what's behind this is the sort of the classic common law, civil law divide. The fact that the ICC is, you know, it's sui generis, but it really, you know, the negotiations were an attempt to satisfy people coming defending their own legal systems. And so the fact that they sort of declined to call for something to be something quite fundamental to be regulated, when so many other things that maybe include things that may be less fundamental to the proceedings should be regulated, I thought was quite interesting.
Yeah, great. So where do you think we go from here? I think many of the things that we've been focusing on, especially the changes to the culture, whether the judges' deliberations or whether it's the Office of the Prosecutor's approach to cases, are obviously difficult things to change. Do you think that the report's recommendations will be implemented going forward? And do you think that they'll make a difference? I'll open this up to the group.
I think it depends. And it will, focusing just on the Office of the Prosecutor, and I know the report deals with other things, but just focusing for a moment on the prosecution, I think it really will depend on who the next prosecutor is. Changing the culture of an institution is hard. It's even harder when it's an already entrenched, path-dependent international organization. I've now worked at several of these courts, at the ICTY, the International Criminal Court, now at the Kosovo Court, and I've seen different management styles. I've seen different phases of institutions and what's possible, and I think that changing the culture of the prosecutor's office at the ICC, and in connection with the other organs, is a monumental task. I think it can be done, but it has to be. It will have to be led by the prosecutor and the prosecutor's staff, and it will require a lot of focus to try to bring about a change in the strategy, the working practices, the accountability, the focus, the climate of the office. That's not just going to happen. That requires that is a lot of work. It is hard. It can be done, but it's a lot of work.
Yeah, Kevin?
Just hop in there, because just to echo what Alex said and to kind of go beyond it, I think kind of my basic response to the report is that there's a lot of wonderful things in it, but that lasting change is not just about implementing the recommendations. It's about ensuring that the right people are working at the court, choosing the right prosecutor, making sure that the members of the OTP staff are recruited and selected well, electing the right judges. If you have toxic people in a workplace, you can have the absolute most perfect procedures and you're still going to have a toxic workplace. And I think if you have people who are really constructive and open and supportive and committed to eliminating sexual harassment and bullying and treat each other with respect, the formal policies are not unnecessary, but they're less necessary than they need to be. I mean, it really starts with getting the right people in the right positions. And I think that will go a long way to dealing with so many of the problems that the experts, quite rightly and insightfully identify.
And that's a really nice segue to some of the kind of excellent questions that have been coming in. So we'll put this out for you to think, and then I can go to Fiona. One of the questions that's raised is what are, in your opinion, the most important skills the next prosecutor of the ICC should have to confront these challenges? So if you can think about that for a moment, and Fiona, I know you had a point that was pending.
Thank you. Just on the last question, I think absolutely the new next prosecutor and who they are is crucial, but we shouldn't forget that also in the next 6 months or so, we're also going to have a new chief judge, president of the court, sometime in I think perhaps first or second quarter of next year, selected by the other judges. And we're also going to have a new president of the Assembly of States Parties elected this December. So I think those are also going to be crucial to the question of implementation. A comment on what makes institutions change, that it's a hugely problematic issue. And you're looking at looking at examples from other courts and tribunals. I think one really crucial thing is that an institution needs to want to change. And for change to be effective. So I'm just thinking about the European Court of Human Rights, for example, which itself identified the need for a really root and branch review and initiated that. In this instance, it wasn't the court itself that initiated this review process. So that makes it even more challenging, notwithstanding, of course, the positive welcoming that statements have been made, of course, from the court principles. And I think just a third point along the lines of what's just been said, I think that about the changing a toxic atmosphere, I think one of the positive recommendations the experts made was to look at having term limits for senior positions. So between the, not the elected officials who all have specific term limits, but the layer below, many of whom, the senior management of the court, who have been there for longer than 10 years. And they're recommending to have term limits for senior positions, which I think will help to sort of refresh. It's a long-term change, it would, of course, but I think helpful as well.
So if I can jump in, I agree very much with that particular recommendation that Fiona just mentioned, the term limits for senior staff. I think that is a really important change, because if you want a court that has a kind of urgency to it, where people are working intensely, you need to have, people can't do that for a long period of time. They have to come and do that for 5 to 7 years, 9 years, whatever the term is, and want to make their mark, want to work hard, want to put everything they have into the place, and then they go. And if you have people who get stuck into positions, then the place calcifies. Elizabeth, to go to your question about the skills for the next prosecutor, of course, I think the next prosecutor has to have, the right character, has to have, some knowledge and experience as a prosecutor. But I really think that for this change to happen, and if we want real change to happen, that the single most important skill for the next prosecutor is actually management skill. Has to be an effective manager. And I know that sounds boring, and it's something we don't often pay enough attention to in senior positions. But in the prosecutor's office at the ICC, if change is going to happen, it's going to come from the top, and that the person who makes that change has to know how to do it, how to take an institution that is set in a certain set of practices and behaviors and visions, and turn that ship around. And that is a rare skill. I've seen a few prosecutors, I worked for a few prosecutors who were able to do it. I've seen others who can't do it. And that is the skill I think that the state should be looking for when they select the next prosecutor.
Yeah. Oh, Fiona?
Sorry, and I know we're going to come on to talking about the elections, but I think in that regard, I wanted to say that I agree with the importance of management skills. I think that as important is if you like, the moral leadership, the ability to provide that moral leadership. I think earlier Kevin mentioned the very serious allegations made through the experts' report of bullying and harassment, and including incidents of sexual harassment. And I think that it's going to be crucial that whoever's appointed to this really important position has gone through a really rigorous vetting to ensure what's called in the statute high moral character. and that's seen to be done, and it's transparently done, and that is in fact done. So that's, I think, for me, up there with the management skills.
Yeah. Well, and then as Fiona mentioned, and we've touched on this in a couple different forms already, but given these elections that are coming up, how do you think the turnover in leadership, particularly in the prosecutor election, could influence and feed into the court's reforms and vice versa? And we'll open this up to the group as well. Kevin?
Can I answer a slightly different question?
Of course.
I mean, I think, the point that I think is really important with the prosecutor election, and this is with all due respect to my civil society friends, and acknowledging the incredibly important role that civil society has played in ensuring that we have more information about the candidates and really questioning their skills and their abilities, and making them defend their visions for the court. This is still fundamentally a court whose survival depends on states. And states have to be the ones that are happy with the next prosecutor. We hope that the rest of us are as well, but if states don't think the prosecutor is effective or credible or legitimate, the court is simply not going to right itself in any significant way. And so I think this kind of tendency to try to outsource all the decision making away from the messiness of the assembly of state parties and the acknowledging of the backroom deals and the vote trading that states engage in, it is still ultimately them that have to choose the next prosecutor, and they have to be happy with the prosecutor. And I hope that after this long vetting system, we will kind of trust states more than we normally do to make a good choice. And I could very easily be disappointed in that optimism, but I just think we've lost our emphasis on who is necessary to make this court work over time, and I think that's regrettable.
Fiona and Alex, any reactions to that, and particularly how you balance finding someone who the states will approve and who has kind of the leadership there, while also having the managerial skills and all the other qualities that we've referenced so far? Do you think that's possible?
So it's been challenging, obviously, because the process has kind of dragged out, and is seems to be a little bit mired now, and it's not clear exactly where it's going. But I agree with Kevin's point, that in addition to the skills that I identified, the managerial skills and the qualities that Fiona identified, the other important thing to have in the next prosecutor is a prosecutor who has the respect of the states, who has the experience dealing with states, who will be able to galvanize states, pull them along. The people, we think of the ICC as having a kind of human rights institution with power, right? Because it can prosecute people and perpetrators, and bring them to justice. But as Kevin pointed out at the beginning, its power is very contingent and very dependent. And really the power derives from being, you can't just call on it. It doesn't, and it's not just there to be used. It has to be summoned. It has to be developed and pulled together and cajoled from the states. And you need a prosecutor who has those skills and experience, persuading states, either through quiet negotiations or through open calls and shaming, whatever it takes in the moment. And I've seen prosecutors that I've worked for use different tactics, both of them very successfully, but you need to know how to do that. So that's something else. I think that's right. I think Kevin's right. That's another thing that the states have to look for in choosing the next prosecutor.
Thanks, Alex. Fiona?
Yeah, of course, it's impossible I'm going to say very difficult, but it's really going to be impossible to find one person that embodies absolutely, you know, the long list of skills. And so I do think that we're going to have to accept the reality that the prosecutor will embody as far as possible the skills that are needed, but a smart prosecutor, which is what we want, and of course will recognize their own weaknesses and how they can make up for those in other senior posts. And so I think that in a way, you know, looking for the perfect prosecutors is like, you know, seeking the Holy Grail. It's you're not going to find it, but of course we want to do the best we can, but not get too stuck on finding everything in one person. Second point, yeah, I completely agree with Kevin. Of course, it's down to states now, but I don't think we should hold back from shaming states into selecting someone on the basis of their qualities and their merit rather than on the other bases, on the basis of politics or regional rotation, whatever it is. So I think that's it is absolutely states now that have to step up and focus on these qualities. And that goes not just for the prosecutor, but for the judges as well, because very importantly, we are also having elections for 6 new judges this December. And they're also, it comes back to states, because the body of states parties can only elect judges based on a pool that is of candidates that are nominated by individual states. So again, I think it's really important to scrutinize how states decide what candidate to put forward. You know, it shouldn't be the president's cousin or somebody that the justice minister wants to give favors to. It should really be somebody who goes through a rigorous process at national level, who meets the qualifications needed. And I was very happy to see a lengthy section in the experts report on that, on the national nomination process by states.
If I can just comment on that, on the point that Fiona just made. I think it's important to note that I see a big difference between the judicial process and the prosecution process with respect to states. With the judicial process, maybe because there are a number of judges, I agree with what Fiona said about the problem of states nominating people who maybe don't have the qualifications that are required for other reasons, political reasons or favors or whatever it is. I have to say, so far in the prosecution selection process, it's been kind of messy. But if you look at the states and how they seem to be engaging the process, I don't see political wheeling dealing going on there. I see an effort to try to find the best prosecutor, and there is disagreement about that, and there's disagreements about the process and how it's worked and so forth. But in terms of just evaluating where the states are coming from and their intentions, to me, I haven't seen any evidence that they're veering towards a political decision or backroom dealing. But maybe I'm missing that. But I don't see that on the prosecution side.
Fiona?
Just a very quick response to that, which is, I think, just exactly as you said, Alex, we don't see it, and we don't see it because it's going on in back rooms, I suspect.
Well, it may be, but I mean, we don't. There's no evidence of that, as far as I can tell, that there's backroom dealing to that there's. I mean, I know there's backroom discussions, but that I agree. Yeah, for sure, it seems that there's that. But is there any evidence that there's backroom discussion to make a political decision, in the sense that And by that, I mean, select a prosecutor for some political reason, some favor to a country or some horse trading reason, as opposed to backroom discussions where states are trying to find the best prosecutor, thinking about the same, criteria that we're thinking about. Those are two very different things. That's what I mean.
I realize we're kind of running low on time here, so I'll open it up for the two final questions and then turn it over to our panelists. One question from the audience. A point that we have been less focused on is the role of victims. So if you have any opinion on whether that will change or whether it could be affected at all in the proposed reform of the court. And then the other is just given the number of law students in the audience today and the kind of challenges that we've identified, whether you have any advice for any kind of recent or soon to be law school graduates who are planning on going into this field, kind of in light of the discussion that we've just had. So I'll turn it over to the group. Kevin?
Sure, thanks. I'll go with the law student question and not the victim question, because victim questions make me really, really unpopular. So I will decline. With the law students, and I know this is going to be an ironic statement given what we're talking about today, but I would suggest to people who want careers in international criminal law that they look beyond the ICC, that they look beyond the special tribunal, they look beyond even Alex's tribunal. There is an awful lot of international criminal law going on in the world that doesn't take place at the international level. There are national prosecutions under universal jurisdiction in 12, 13, 14, maybe 15 countries right now. The ICC is not prosecuting Syrian war crimes. It's Germany that is prosecuting them. It is other countries in Western Europe. There's so many under-serviced areas of international criminal law that take place largely at the national level that needs so much more work. We need to build greater judicial capacity and investigative capacity and prosecutorial capacity in domestic criminal law systems around the world. We need to disseminate international criminal law and international humanitarian law more widely. We need to think about regional courts, whether it's in Africa or anywhere else that can deal with international crimes. These incredibly important areas that are so underserviced, they're lost because all the oxygen in the room is sucked up by the ICC. The ICC is always the first resort or the first point of interest, and not, as the court is designed to be, the last resort. And I think that we need to stop thinking that international criminal law is synonymous with international institutions, because by and large, the most important work in the world that is being done today is at the domestic level. And if you want to look at something hopeful, it isn't anything the ICC has done. It is the conviction of Habre, under an African former head of state in another African country via universal jurisdiction. That's the biggest triumph we have in international criminal law over the past couple of decades. And I would go to the mat defending that position. So law students, don't think that if you can't get an ICC job, there's no future for you in international criminal law. There's lots of futures for you in international criminal law. You just have to look a little harder and be a little bit more entrepreneurial about your interests.
Thanks, Kevin. Alex or Fiona? Fiona?
Yeah, I strongly agree with what Kevin just said. Yeah, really important. Do, however, bear in mind that there are opportunities for internships at the court, and I believe, if I'm not wrong, the experts may have recommended that they should be funded internships, but they haven't, because they haven't been for the last few years. But I should respond on the victims question. The experts did recommend a full appraisal of the victim participation scheme, how effective it is, so we'll see. It seems to be constantly in a state of being reviewed. So let's see whether that manages to bring about any improvements. But I think one thing which is really important that should be considered is when it comes to reparation, because it's been quite damaging that there have been really disparate approaches by different chambers to victim reparation after a conviction. And I think that that's an area that could really merit some standardization. So I was happy to see that, that recommendation.
Thanks, Fiona. And Alex, any final thoughts?
I see we're just about out of time, so I'll just say I agree with Fiona and Kevin on the law student question, and I would go a little further and say that law students or recent graduates who want a career in international criminal law should develop criminal law skills in domestic systems and then bring them to the international criminal law world. They will be much happier, and they'll be able to contribute more if they do that. And I'll leave it at that.
All right. Well, thank you all for taking your time to speak with us today. I think any one of these topics or questions could have been its own panel. So I think we covered a lot of ground, but thank you very much. And thank you again to the audience for joining, and for the ILW board for putting this together.
Thanks, everyone, and thanks for tuning in the audience. I'm sorry we didn't have more time for interaction, but that's the one thing that Zoom is particularly bad at.
Thank you, Elizabeth, and thank you, Kevin and Fiona.
Thank you. This has been an extremely interesting panel. Thank you.